Thank you, and be seated, please. Are there any matters that need court attention from any juror before we begin this morning? Hearing none, let me ask all of you a question. Prior to the defendant just coming into the courtroom this morning, had any of you seen him this morning? Anyone? Okay. All right. Members of the jury, both the state and defendant, have now rested their case. The attorneys now will present their final arguments to you. Please remember that what the attorneys say is not evidence or your instructions on the law. However, do listen closely to their arguments. They are intended to aid you in understanding this case. Each side will have an equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defendant has given its closing argument. State ready to proceed?
Yes, sir. Good morning, and I want to thank you for your attention during this trial. This was a horrendous crime that happened. And I don't think that I'm exaggerating whenever I say that. Mr. Jones was shot multiple times at point blank range, multiple times. And during this incident, Mr. Jones, after being shot, went down to the floor, and the defendant, you can see in the video, reaching over the counter and continues to shoot at Mr. Jones multiple times. Mr. Jones is lucky to be alive, and he suffered tremendously. You heard about his disabilities that he has nerve damage to his arm, nerve damage to his leg, was in a hospital for many weeks, still having effects of it, both mental and physical. So this was a truly horrendous crime. Now, I don't think that there's any doubt about what had happened to Mr. Jones. Mr. Jones was shot multiple times, and he was robbed. I don't think the defense would even dispute that. I think the only issue in dispute is the defense says that it was not the defendant who committed these crimes. However, we say it was this defendant here in court today is the person that shot Mr. Jones. And you don't have to take my word for it. Consider the evidence that shows that it is this defendant that committed this crime. Now, first consider the testimony of Alan Jones, the victim in this case. Mr. Jones testified as to the events of what happened to him. He also went into great detail about his ordeal, about how he was shot multiple times and has not even fully recovered, but he had a long recovery, was in the hospital, and still has complications from that, still has some disabilities from that. And at the end of his testimony, and it was brief but very important, at the end of his testimony, Mr. Durrett asked Mr. Jones, "Do you see the person here in the courtroom that shot you?" And Mr. Jones said yes. And Mr. Jones then pointed out the defendant as being the person that shot him and robbed him. Now, on cross-examination, Mr. Collins asked Mr. Jones whether he was sure that this is the person that shot him. And Mr. Jones said, yeah, there is something that does make him sure. And Mr. Collins even asked, well, what was that? What is that? And Mr. Jones replied, it's the eyes. See the eyes. The eyes don't lie. Now, consider that Mr. Jones did get a good look at the person that shot him, because not only did he encounter him once, but he encountered him twice. Because remember the evidence in this case. The defendant went into the pawn shop on April 18th, 2 days before the robbery. And Mr. Jones was able to observe him and interact with him in that pawn shop. And then a second time when the defendant went back in there on the 20th. So there were 2 times that Mr. Jones got to observe the defendant. And if you recall, this pawn shop is pretty small. Not much space in there. Now, I know the video footage from the security camera really doesn't show the scope or the dimensions of the pawn shop, but remember, we had the video camera or the body camera from the deputy that first responded. And if you recall, Deputy Morello, he first responded and was treating Mr. Jones there on the floor. So you kind of got a good view of the pawn shop from that video. And it is quite small. I mean, anybody that's in that pawn shop, you're pretty much up close and personal with them. And if you see the two interactions that Mr. Jones had with the defendant, he was within arm's length of the defendant. So Mr. Jones got a good look at the defendant. But more importantly, Mr. Jones has every incentive, every reason, every motive to get this right. It's not going to serve Mr. Jones to just convict any old person. Sure, whoever, yeah, he's the guy. That would not satisfy Mr. Jones because Mr. Jones suffered tremendously from this shooting. Suffered tremendously. And you heard how much of an ordeal he went through. So consider that. This man who went through such an ordeal has told you all, told all of you, that this defendant is the person that shot him. Don't dismiss that. Don't overlook that. Don't shrug that off what Mr. Jones has told you. Given the ordeal that he's went through, he's told you this is the person. That alone is incredibly compelling. That alone is enough to convict the defendant. But there's other evidence that suggests the defendant did this. And first, let's talk about the car that was used in this robbery. Because we connect the car to the crime, connect the defendant to the car, means we connect the defendant to the crime, right? Simple logic. So the car that was used in this case, and we have it from April 18th video, the first time that the defendant went there. Here's the silver car parked out there. That same day, on April 18th, the same day, the first day that the defendant went up to the pawn shop, then he and his friends drove to Empire Pawn in Lake City, same day. So just barely an hour later, we have the same car being used by the defendant. And then we have from Mr. Travis Williams, who was working next door at Melody Church, this photograph, same car being used by the defendant for this crime. Now, what connects the defendant to this car? Well, first we do have the videos of him getting in and out of the car, but to connect the defendant further to this car, to show that this was actually his car, not Victoria Fender's car or anybody else's. Recall the rental records. Remember Miss Lassiter from the rental company? She testified that two women had actually rented the car, but they gave an address which was the same address that they had on file for the defendant, further connecting him to the car. And what about one of the persons that was renting that car? Miss Lassiter said that one of the persons on the rental agreement was Tara Lowry. And if you recall from Deputy Kelly, he got the Facebook records for Tara Lowry and showed that there is a connection between Tara Lowry and the defendant. Now, another thing that connects the defendant to the car. You remember, after the car was taken into custody, it was processed by the crime scene analyst, and he got swabs for touch DNA on the steering wheel. And then the DNA analyst says that one of the DNA profiles on that steering wheel matched the defendant. Again, connecting him to the car. And lest we forget, when the car was actually found and taken into custody, guess who was with the car? And guess who was apprehended with the car? The defendant. Again, the defendant is connected to the car connected to the crime, defendant is connected to the crime. Something else about the car. If you recall from the rental car company, we got the GPS records that shows the location of the car. Not every minute of the day, and it was kind of random, as the Miss Lassiter was talking about. But those GPS records do show something interesting. On April 18th, the car was in Live Oak. And what do we know about April 18th? The defendant and Victoria Fender went to the pawn shop, Greenleaf, or Goldleaf, on April 18th. Now, unfortunately, this GPS doesn't show the location at the time of the robbery, because remember, the time of the robbery, very important. April 20th, that's the date, 12:35 p.m., according to the pawn shop video timestamp, is when the defendant and Victoria Fender went into the pawn shop. So April 20th at 12:35. Unfortunately, with these GPS records, on April 20th, it goes from 4:58 a.m., which is roughly 5 in the morning, then skips all the way to 2:35 p.m. as the next location. So we don't have the location at the time of the robbery. However, something interesting about these GPS records. They do show that on April 20th at 2:35 p.m., roughly 2 hours after the robbery, the vehicle is in Lake City. And if you recall the testimony that we heard, after the robbery, the defendant went to Lake City. So the GPS records do corroborate that. But something else that's interesting about these records. From 12:35 on April 20th, so roughly 2 hours after the robbery, then the vehicle remained stationary for 2 days at the very same location. Stationary for 2 days. Now, remember, we heard testimony about how officers did surveillance on this video at this location in Lake City. And what they found was the vehicle was parked at a yard with a tarp or something covering it. So think about that. Before the shooting, before the robbery, GPS records showed this vehicle all out and about. Then after the robbery, just 2 hours after the robbery, the car is now parked with the tarp over it being hidden and remains there for 2 days, unmoved. As if somebody wanted to make sure, hey, don't want nobody to be seeing this car, let's hide it away until things cool off. But then after 2 days, guess who gets in the vehicle? Because can't keep that vehicle there forever, so got to start to get rid of it. Then who gets in the vehicle? The defendant. That's who gets in the vehicle. After hiding it for 2 days, the defendant gets in the vehicle. Now, you may ask, well, seems kind of reckless and stupid to get inside that vehicle after 2 days, but I would submit to you one thing. Think about the robbery in this case. It was pretty reckless and stupid too. The reckless and stupidness of going into a pawn shop at 12:30, even during a lunch hour, at least wait till after lunch. Instead, in the middle of the day, during a lunch hour, the defendant went into a pawn shop, gunned down the owner, and took off. That's pretty reckless and brazen. So I guess after 2 days, getting inside the car, that may be stupid too, but that's par for the course for what the defendant has done in this case. Now, I want to talk about the videos in this case and view the videos again, because I think it's important. And first, let's look at the video from April 18th. This is the first time that the defendant went into the pawn shop with Victoria Fender. I would make it larger, but the last time I did that, it froze up, so I'm just going to leave it like this for right now. But you see the car, same silver car that we were talking about. And in the second, right here, you see Victoria Fender getting out of the driver's seat. Now you have the defendant getting out of the passenger seat. I just want to note the shoes that he's wearing. White shoes with 3 black stripes. Yeah. White shoes, 3 black stripes. You can see a slender build. You see that it doesn't have a mask when he goes in, but then exits, goes back to the car to get a mask. And again, you can see the shoes, white shoes with 3 black stripes. Now, we go on. Because that same day, the defendant, just about an hour later, then went to Empire Pawn. And we have the video from Empire Pawn, so let's look at that. You see the defendant dressed same exact way. You get a better shot of the defendant in this video. It's a little bit clearer to see him, and it's clearly the defendant. Same person sitting here in this courtroom today. And you can also see white shoes with 3 black stripes. See his slender build. Also notice his haircut. His hair is cut very short to his head. Not quite shaven, just very short. Very short haircut. Not quite to the scalp, but pretty close. Fast forward a bit. You see Aaron Donaldson, the defendant's friend, with the camouflage shirt and the defendant right there. You can notice one thing about comparing the two. The defendant, again, his haircut is much shorter, closer to the scalp. Aaron Donaldson has a little bit more hair sticking up off his scalp, about an inch. Now, let's look at the video of the incident on April 20th. Here we have the defendant and Victoria Fender walking up to the front entrance of the pawn shop. Note the defendant, you can see the same white shoes with 3 black wearing 2 days earlier. You also see a slender build. Now, this time the defendant is wearing a ball cap. However, you still see from the sides, and particularly the back, that it is still somebody with a very short haircut. Also a slender build. In fact, from the back, you can see the fact that it is more clean shaven, almost cut really short in the back, and the hat is formed closely to his head, no hair sticking out like it would be if Aaron Donaldson was wearing the ball cap. Now, again, there's no doubt, on April 18th, the videos that we saw from Empire Pond and Goldie Pond, but particular Empire Pond, because it was a little bit clearer picture, that's the defendant there on the 18th. You could see his build, you could see his short haircut, you could see his shoes. And then we have here, on April 20th, same slender build, same shoes, same short haircut. One more thing I want to point out. If you recall from the testimony from Victoria Fender, okay, she says that before the defendant and her went to the pawn shop, she was wearing a backpack, and she put the gun in her backpack. The gun was in her backpack because the defendant couldn't put the gun anywhere where it could be noticed, so had to put it in the backpack. If you look closely at the video, you will see the defendant reaching around, touching her back. Now think about that. He's got the gun in her backpack. He's having to kind of touch her. He doesn't want to look suspicious by just reaching down in there, so he's touching her periodically on her back. Then he goes in and gets the gun from the backpack. Now also note one thing, and you heard this from Victoria Fender, the defendant and her were wearing gloves at the time. So they were wearing gloves the whole time they were in the store. And we're going to talk about that a little bit later, but just note that. You see them running away, going towards Melody Church where Travis Williams saw them. So, yeah. We have the defendant going into the store on April 18th. You can see the shoes that he's wearing. White shoes, 3 black stripes. You can also see a wristwatch that he's wearing that'll come up later. See the same wristwatch. You see the defendant here from Empire Pond, and you get a really clear view of the defendant. That's clearly the defendant. Even though he's got a mask on, you can still see it's him, and he's wearing those white shoes with the black stripes. Then we have the day of the offense, where the defendant is walking in with the same white shoes with the black stripes, and as he's running away out of the store with those same white shoes, black stripes. So we know from the Facebook records that we got from Tara Lowry, this is the defendant being depicted here because there's the watch, and also it mentions the fact that he's Jamar. So this Jamar that's in the Facebook photos is the defendant, same watch, but more importantly, same shoes. White shoes, 3 black stripes. And when was this posted? April 2nd, 2020. 18 days before the shooting. Another thing these records show us is that there's a reference in these records to a Judy Tilly and a Jamar Mudal. And again, Jamar Mudal. Why is that significant? Because remember, we got the Google records for the defendant, and it was in the name, email name was Mudafi, but the username was Juvie Tilly. Remember, we heard evidence from Victoria Fender that the defendant goes by Juvie Tilly. All right? So these are the Google records for the defendant. And this is what's significant about the Google records. These show his internet searches, what he typed in to search for things. These aren't the directions, we'll get to that in a second. These are just internet searches, where he's searching for information. And what does he search for on April 19th? Now remember, the 18th, that was the first day he went to Gold Leaf. The 20th is the day of the robbery. But now we have on April 19th, the day after he's been to Gold Leaf, the day before the robbery, is the defendant is searching for Gold Leaf, searching for information on Gold Leaf. Well, if the defendant had already been there on April 18th, and as the defense would contend he didn't go back on the 20th, then why on the 19th is he searching for information about Gold Leaf? The only logical conclusion, he was searching for information on Google about Gold Leaf because he was planning on going back to Gold Leaf. Planning on going back, which he did on April 20th. Something interesting about these internet search records also is on April 21st. This is the day after the robbery. So the day after the robbery, the defendant is searching for information about the armed robbery. It says, 2 suspects sought an armed robbery. Suwannee Democrat News. The defendant is searching for news about this incident. Why on the day afterward is the defendant searching for news about this particular incident? What interest does he have in this? Well, maybe he's searching for information after the robbery because he wants to see what information is out there, what the police may know. Then we have the Google Maps and directions information. And we first have on April 20th, this is the day of the robbery, April 20th. And remember, the robbery was at 12:35 p.m. But at 9:25 a.m., earlier that morning, the defendant is searching for directions to Walmart, okay? And by the way, if you'll notice, it's given at UTC time, so it's 1:25 p.m., but you always got to subtract 4 hours to convert it to Eastern Standard Time. So these records always show it in UTC time, so you always got to subtract 4. So again, we have the defendant at 9:25 a.m. on the day of the robbery, searching for directions to the Walmart in Live Oak. Why is that significant? Well, a couple of reasons. First of all, remember what Victoria Fender said. The defendant and her were driving from out of town and coming to Live Oak. The one thing is, Live Oak is near the interstate exit, so if the defendant was looking for the right exit to get off of, he might be searching for the Walmart. But also, Victoria Fender said that they went to Walmart. Remember, she said the morning of the robbery, they went to Walmart to go get some clothes that she actually stole. And then after that, after they left Walmart, what did she say they did? Said that by Walmart, went down a side road to a secluded area where the defendant got out and shot his gun. Remember, she said he test fired the gun. Okay? Well, that's interesting. Because at approximately 10:06 a.m., and 10:05 or 10:04, a.m. that morning. At 10 o'clock that morning, the defendant is searching for maps in this area. And specifically, the maps he's looking for is this map that shows an area not too far from the Walmart, but shows some areas behind or off the Ohio Avenue Road, just some secluded areas. And then he's also looking for a map at Walmart that shows the surrounding area. So again, remember, Victoria Fender said that he went down a secluded road to test fire the gun. And here we have him at approximately 10 a.m. that morning, searching for areas around Walmart, particularly secluded areas. That matches, fits like a glove. It's exactly what happened. What else do we have from these Google records? Had the defendant searching for directions to Lake City, Florida. Now, this is significant because remember, the defendant went into the store at 12:35 p.m., was there no more than 5 minutes, was out of the store by 12:40, by 12:40. She said they stopped, get rid of the gun, get rid of the clothes that they wore. Then they continued on to Lake City. So somewhere between the pawn shop and Lake City, they stopped to get rid of some stuff, then continued on to Lake City. That's interesting because this Google search shows that at 1:03 p.m., so just a few minutes after the murder, or not the murder, the attempted murder and the robbery, the defendant is searching for an area. And if you pull up the map, and the map says that around this area from your device, pulls up this map. And what does this map show? You see Live Oak on one end, and on the other end, on the far end, right off this map, but if you continue on, you'd be in Live Oak. So right center of this map, you're in between Live Oak and Lake City. Just like Victoria Fender said, this fits like a glove. She said that they were going to Lake City. They stopped on the way. They got rid of the gun. They got rid of the clothes. And this map verifies that. Now, I want to talk a minute about the DNA evidence that you heard in this case. And we'll talk about the DNA evidence we got from the car. But one thing I just want to point out, in case you're wondering, well, why wasn't there any DNA evidence from Goldley Pond, the actual crime scene? But remember, the defendant was wearing gloves, a long shirt. So was Victoria Fender. Remember, I asked a DNA analyst, if a person wears gloves and they touch something, would you expect there to get DNA? She said, no. And of course, that makes sense. DNA comes from shedding skin cells, sweat, etc. So the fact that the defendant and Victoria Fender were wearing gloves, that's the reason why we didn't get any DNA evidence from the scene, in case you were wondering about that. But we did get some DNA evidence from the car, the silver car. And I talked about that a few minutes ago. The steering wheel had the defendant's DNA, but also there was a cigarillo, or cigar-like substance, that was found in the vehicle that had Victoria Fender's DNA on it. And that just fits with everything else. The two of them were together. But now that just brings us to Victoria Fender. Because Victoria Fender came in here and testified. She admitted her part in these crimes. And she said that it was the defendant that shot and robbed Alan Jones. Now, she's admitted her crimes, but she's not been sentenced yet, and that's important. And she was asked, as part of your plea, whenever you pled, you've yet to be sentenced by the judge, but you've agreed to testify truthfully in this case. And she said, yes, she has to testify truthfully in order to get any sort of leniency. Now, if she doesn't tell the truth, that's not going to be good for her. She must tell the truth. If she gets caught in a lie, that's not going to be good for her. Now, Is Victoria Fender, is she smart enough to know all the evidence out there? And it's like, well, I'll just tell a lie and nobody will know and I'll get away with it? Or is she going to be more of a self-interest and say, I'm just going to tell the truth and try to get as little out of this as I can because that's in her self-interest? So she has every motive just to tell the truth. And she says that it was a defendant that was with her. And the defendant is the person that shot Alan Jones. And really, all the evidence confirms that. In fact, these Google Maps and his Google search histories confirm everything that she says. Now, the defense, I know when questioning Victoria Fender, asked, well, was it really Aaron Donaldson, your boyfriend? Was he really the one that did this, and are you just covering up for him? And she said no. But I would also submit to you, all right, that really doesn't make any sense for Aaron Donaldson to be the one that went in there on the 20th. Because think about this. On April 18th, the first day, who went in there with Victoria Fender? The defendant. That was the plan. That was what they were going to do. Doesn't really make a lot of sense to change it up on the 20th and now for Aaron Donaldson all of a sudden to go in there. Because think about this. Victoria Fender said that the plan was they were going to go in there on April 20th, the day of the robbery, and tell Mr. Jones, hey, remember us? We were in here a couple of days ago. We sold that ring that we were trying to sell you, but now we want to look at the ring that you were showing us on April 18th, or a couple of days ago. Remember, that was the plan. And Alan Jones says that's what happened. I have no reason to doubt Alan Jones. He says, yeah, they came in and they said, sold the ring, and they want to look at the ring they were looking at from the other day. So if that was the plan and that is what happened, then it really doesn't make any sense for Aaron Donaldson to go in there with that plan. For Aaron Donaldson to go in there with Victoria Fender and to say, hey, remember us from 2 days ago? We want to look at that same ring. And Alan Jones say, I don't remember you coming in there. Were they just going to take a chance and say, well, maybe Alan Jones wouldn't remember? But why would they put that kind of glitch in the plan? Because the plan was, hey, let's not raise any sort of suspicion. Remember, there was all this talk about, let's not raise any suspicion. Let's not do anything that's going to cause attention. So why would they go in there with a different person and raise some suspicions and cause that kind of a glitch in the plan? And furthermore, it's the defendant that's wearing the same shoes on the 18th as he does the 20th. You can see Mr. Donaldson's shoes in the Empire Pond video. He doesn't have white shoes with black stripes. And remember, Aaron Donaldson's got some hair. He's got about an inch worth of hair that would have been sticking up over that cap, or that cap wouldn't have conformed. And the person we see on the 20th that shot Mr. Jones has very short hair, almost slick hair. Mr. Donaldson doesn't have any connection to this car, but the defendant has plenty of connections to this car. It was the defendant that was searching on Google for all these different things. It was the defendant's Google account. But you know, we go back to where we started with Alan Jones, his testimony. Now, he got a live, in-person view of the defendant. I know these videos may not look good sometimes, but you got to remember, somebody live and in person, they get a better view. So just because these videos may be a little blurry doesn't mean that Mr. Jones's view was blurry. Mr. Jones got an excellent view of the defendant. And it was barely 48 hours from the time that the defendant came in on April 18th to the time that he came in on April 20th to commit the robbery. Mr. Jones, he says on Saturdays, which was April 18th, he closes at 2. So the defendant and Ms. Fender was one of the last customers he saw. Then he turns around that Monday, opens up again, and come noontime, there they are back again. Now, Mr. Jones, not only did he come in here in court and say, listen, you know, I know who was a shot, not by name, but he can recognize him. He also immediately, and think about this, immediately after being shot, because if you remember the video from the deputy that was administering aid to Mr. Jones as he's laying there on the floor, He was asked, still in agony, screaming, do you know who shot? And he immediately says, they were here 2 days ago. They were here 2 days ago. They're on video. He said that immediately, even under all that stress. He was sure. And we know it was the defendant that was there 2 days ago. There's no question about that. So if it was the defendant that was there 2 days ago, then it was the defendant that was there on the 20th. And Mr. Jones was right about that from the very beginning. Now, and again, Mr. Jones has no incentive to lie. He's been through a lot. And he's come in here and he's told you that it is this defendant right here in this courtroom that shot and robbed him. So I'd ask that you consider all this evidence, especially Mr. Jones's testimony. And you find the defendant guilty as charged of all 3 counts, guilty of attempted first-degree murder, guilty of attempted felony murder, and guilty of robbery with a firearm. Thank you.
All right, thank you, Mr. Weed. Members of the jury, we're going to take a short recess before we hear the defendant's closing argument. I have right at 9:57. If I can get all of you back in your seats at 10:10, that'll give you just over 10 minutes to use the restroom, stretch a little bit. Just a reminder, when you do go downstairs to deliberate on your verdict, you won't be allowed to take any electronic device. If you choose to have those devices with you, when you're back up here, we'll of course keep an eye on them when you're deliberating. So, or you can lock them up in your car, whatever you want to do. Just want to let you know that you won't have them in the jury room when you deliberate. So if you want to leave them here when you do so, that's fine. We'll keep a good eye on them for you. Remember, again, the admonishment I've given you throughout the case, not to discuss it, form any opinions about it. Don't do any research at all whatsoever on it until, of course, you go back to deliberate and you can discuss it freely. Any questions from any member of the jury? Any further instructions requested from counsel for the state? Defense? All right, we'll be in recess then until 10:10. They call it time being open.
Monday, all individuals over the age of 40 will be vaccinated.
I thought 16.
Then the following Monday, all over the age of 18.
And Georgia might be 6. Yeah. That's the way. All I can tell you is, I'm older
right, Mr. Collins, ready to close? And you may proceed.
Good morning, ladies and gentlemen. First, I want to thank you for the time and attention that you bring to this matter. I can't say, like I normally say, I kind of watched you do your work because I'm looking the other way. Normally, I'd be over there and you'd be over here. And I think it's kind of creepy if you stare at jurors too much too long anyway. I don't think it helps anything. But I did see occasionally people writing. I'm going to recite what I think I heard at times in my closing. And I feel collectively what I say about the evidence will be verified. But if it's not, I mean, from y'all collectively, because we all hear sometimes different things and see things differently. But the point I'm trying to make is if what y'all conclude is different than what I said, rely on your collective recollection, okay? I don't think there'll be an issue, but, you know, y'all will have to feel comfortable with what you're doing, and I don't want to be someone who appears to be giving you a line of, you know. We get to argue at this point as to what we saw or heard. You probably remember I didn't give an opening statement. I didn't give an opening statement because of the nature of this case, and it's needed to see what the evidence truly is, what people truly say, not what you think they're going to say or what you believe they're going to say or your spin on what they're going to say. So with that in mind, what I would like to do at this point is talk about some of the things that the state addressed in their closing. Then I'm going to go over what I heard the witnesses say, what I saw the exhibits show, mainly the videos, and we'll address those. Now, the state's going to get up behind me, or, you know, they have the burden of proof, so they'll be able to come up and, like my grandson says, he's full of beans. Well, I can submit to you, I'm not full of beans. And I think that what I say to you, God, I hate these things, you need to very much consider, because it will be evidence that we've had and not my words of what I believe you should believe. I believe you should believe what you interpret individually and collectively. If you do not believe the same as another juror, that's okay. If you do, that's okay. So with that having been said, all right, I am not smooth. This is not TV. When I was younger, I was smoother. But I realized I asked the sergeant from Lake City a question about two people being in the car. And he never said anything like that, but I didn't even understand really what he was saying. So maybe that would put doubt in your minds about my recollection of things. He did mumble a bit. It was the sergeant. Well, he didn't do anything bad. That's why I asked him the question, what are you talking about? A white fella and a black fella in the car? And I don't think he even mentioned anything like that. Well, I said I ain't smooth. When I was younger, I was smoother. I don't know if that has to do with, I don't know. I got more age spots on top of my bald head. Mr. Weed is an excellent attorney. He is. Very persuasive. But his closing is not evidence. It's his belief, his take, just like mine. It's his argument of what he believes you should see. Before we began the trial, the court instructed you on some very basic concepts that are important. These jury instructions are important, but I about fell asleep listening to them. I submit that you read them. You promised me you were going to pay attention to the trial and keep your minds open. You did, and I believe you've done that. But to do the hard work that you promised me you were going to do, you're going to have to read them jury instructions. You're going to have to go down, consider them. You should, because that's the law. That's the law. The evidence and the law, and then you give what weight you want to us lawyers. I don't think anyone's here trying to intentionally mislead, but what we say is not evidence. So let's consider the state's closing argument as to the evidence that they've talked about so far. Mr. Jones, the victim, I don't believe I would ever submit to you, because I don't believe, and what I believe is not relevant, that he's lying at all. I don't believe that he's intentionally putting forward an identification that's based upon a lie. I don't believe that at all. I'll consider Mr. Jones a little more when we get back to going over his testimony in regards to other people's testimony and the eyewitness identification jury instruction, which is the law that you must consider when you're considering these most important issues. The state says that he saw the defendant 2 times, the 18th and the 20th. The state said that the defendant interacted with Mr. Jones. Mr. Jones said he never spoke to the defendant, never heard his voice. Do you remember I asked him, no, he never heard his voice. Now, there could be nonverbal interaction. I understand that. The best evidence is the video on both the 18th and the 20th. What's important is look at where the people are, look at the mask, and look at the opportunity of how long Mr. Jones actually was looking at Mr. Tilley, had the opportunity to describe him or remember what he looked like, not only on the 18th, but again on the 20th, because I believe what is significant in its human nature is not the exact person, but the nature of, unfortunately, a black male and a white woman coming into the shop. I would remember that, and I believe, I would assume and believe that they were the same people that came in previously. At the Empire store. Look at that video. I can tell you right now, I'll get into it in a bit, but Mr. Saperstein was closer and had more of a direct conversation and spent more time looking at my client under very non-stress conditions than Mr. Jones unfortunately had with Mr. Tilley, my client. And guess what we know? Mr. Saperstein never identified my client for anything. He didn't even say he was the person on the video. And I guarantee you if he had, we'd have known about it. So he made no identification of him. under much less stressful conditions and had more time to do it. You're not supposed to be angry or feel sorry for anyone. The judge has instructed you on that. And it is hard. It is hard not to feel sorry for Mr. Jones. Whatever is anything he did not deserve. And the person who did that should be punished. I'm not some bleeding heart liberal. I'm hoping that you can search for the truth, because that's all we're all doing. And the truth on everything is not so easy to find. The car, it's not really an issue that Mr. Tilley is connected to it. It's not. But the car associated with the crime, associated with the defendant, doesn't mean that you conclude then the defendant was the shooter. That's just a little bit too much to conclude just on that. Now, there's going to be a lot of other things that they have already started to tell you what you need to believe beyond a reasonable doubt, because that's the standard on each one of these matters, beyond a reasonable doubt, the highest standard we have. Mr. Jones, this is important. I understand you can describe the car as silver or gray. I understand that. But I'll tell you, in that video, it looked white. And that's what he said it was. He said it was a white car, right? He said a white car. I wouldn't normally nitpick that, but white does not look like silver or gray, but it can in the video, based on lighting and other matters. You'll have an opportunity to look at it. So why is that important? Mr. Collins, because his memory is coming not from individual memory, it's coming from the videos that he's been shown. He said what? I suffer from short-term memory. He said that. Short-term memory might get you to be able to retain a phone number for a little bit, but it alone is not going to let you remember something that's over a year ago. So how much is his testimony relied upon and based upon the videos? He admitted he had been shown them, I think, a minimum of 3 times. I have no reason to doubt that. You don't have to see them very often to mistake a car's color as white when it's silver or gray, when the video clearly appears that it is white. Now, I'm talking about the car exhibit that's shown in the video at the pawn shop in Live Oak. This is different. This looks more like silver or gray. But he would have no reason to look at these videos, just the one at his pawn shop. So what does that mean? Oh, I'm nitpicking again. What does that mean? It means that his identification, like all of ours, is subject to being influenced, maybe more so if you have short-term memory, and that what he's testifying about comes from his view of the videos being shown to him numerous times, as opposed to his memory of what really happened at the time. Okay. Mr. Saperstein again, and you can look at all those videos, or that video. He never identified him in a much less stressful way. The car. It was clearly associated with Mr. Tilley. I would be ridiculous to assert not. His DNA was found on the steering wheel. Miss Fender, not Miss Pender. I might have called her the wrong name. She's associated with the car because of DNA. Those are the only 2 submissions, weren't they? Only 2. Nobody other than those 2 were tested, at least from the evidence in this courtroom, and submitted. The car should be considered very much from you, because it certainly transported 3 people at certain times during the 18th and the 20th. That's really all we know from the evidence, but I don't think it's unreasonable to conclude that all three of them came from Tallahassee. We don't have any evidence of that, but I think it's reasonable to conclude that. But let's remember how they left. Who left in the late hours stealthily together? Aaron Donaldson and Miss Fender, staying in a hotel room. No evidence that Mr. Tilley stayed in the hotel room. Oh, she said, oh, he paid for it. That's what she said, meaning my client paid for it, but it was somebody else's name. All right? What's significant is he isn't with them. He isn't with them. Also remember, go back and hopefully your notes pick this up. When asked about the jewelry, she kept all the jewelry because Aaron owned her. Aaron owned her. Aaron owed her the jewelry. Mr. Weed, appropriately, depending on your interpretation, characterized my client's actions as reckless and stupid. I can't disregard that, but for what reason? For being with them or for being someone who would connect all this evidence without any regard for it being uncovered if he's the same person that Miss Fender says is stealthy enough to know I'll pay for their room, but I'll put it in somebody else's name. I don't think there's been any question that there was no attempt to hide the identities on the 18th of the car or himself when he went there on the 18th. He didn't even wear a mask, but he knew to stop and go get one. I submit Mr. Jones told him to go get a mask. I don't know. But if you're going there to have a ring trade appraised or business about a ring, and you're not wearing a mask, you're not being too stealthy, because what was in place at that time? We were already masking up. This is during the early COVID pandemic. And you know, I always thought when I first started seeing these masks appear, I'm like, my goodness, the criminals can have a heyday. I do not disagree that Mr. Tilley went there on the 18th just exactly for the reason that Fender said. Now, I know you think, Mr. Collins, you want to believe her when you want to, and you want the jury not to believe her when you want to. I'm just going by what the evidence suggests. This is something you have to consider. I didn't make the evidence. Mr. Weed and Mr. Drett did not make the evidence. We're doing our jobs. The fact that it was the defendant's car is somewhat important, but that does not make him the shooter. Ms. Fender also said the reason I went to Lake City was because Mr. Jones advised him to go there. Look at the video of the actions of my client, Mr. Tilley, in Lake City. He's doing exactly what he did on the 18th, which I believe was the same day, in Live Oak. Is there any attempt for him to be stealthy? Well, here's the thing. No, there isn't. We don't know why Miss Fender, I believe correctly, if anybody won't say it, suspiciously was driving that car around in parking lots. It just didn't make sense. I mean, it's common sense. She's planning a getaway. That's what it looks like. Now, who planned that? She said nobody did. Okay? She said on the 18th in Live Oak and on the 18th at Lake City, there was no plans for this. Aaron the jewelry, Jamar's got a car, and she's driving suspiciously, we know, on the 18th. But it's after Jamar's out of the car. He's inside doing the ring thing, just like he did over there. Did they drive suspiciously on the 18th when they went to Gold Leaf or the pawn shop here? No. You see him pull right up. You see him get out without a mask, and then he's told to go get one. I don't think that Miss Fender is completely done with Mr. Donaldson yet, and her truth is carefully calculated to inoculate him. She wants her good deal. She wants her good deal, 7 years followed by probation, and she's trying to cut the cake in half, protect him, throw him under the bus, and hope that that satisfies the justice system. Now, here's what you need to think of. My client's been charged with attempted felony murder. You read that instruction and you apply it to Miss Fender. She pled guilty to robbery. She ain't been sentenced yet. She's the one that sat over there and smashed the jewelry box while Mr. Jones is lying on the floor bleeding, possibly to death. Thank God he wasn't. We're going to believe her. We're going to talk about her a little more when we get to accomplice testimony. I understand Mr. Weed's reliance on shoes. I understand them completely. Shoes are common. They can be changed. If this case is such an open and shut case with all this evidence as it was represented to you with no problem in the opening statement, we're getting down to telling you what you're seeing, which maybe not what you're seeing. You have to decide. I can't tell you what you see. I'm not going to do that. But that doesn't make anybody a shooter. Pender said she did not know why the person in the video on the 20th put their arm around her. She did not know why. Why didn't she say to get the gun? She knew where it was. You think she didn't know when that arm went around her who it was that was getting it and what was going to happen? She showed no emotion. When that man was shot, she went over there and started stealing rings that she got to keep. Never been recovered. Which will remind you, nothing's ever been recovered. They apprehended him in the same car by himself. No evidence of crimes, no guns, no jewelry, no nothing. Who left at 11 o'clock on Friday and went back to Tallahassee to get out of town? Oh, well, just nothing, we're certain. These internet searches, man, they can be interpreted any way you want to interpret them. We know he was at Gold Leaf on the 18th. Why would he be searching for instructions to go back to Gold Leaf on the 19th? It's on his Google or it's on his Facebook. People use other people's things. These three all together were doing something. Okay? That does not make him, if you don't have Alan Jones' testimony, and I'm going to kind of submit to you why, according to the law, it shouldn't be accepted as easily as the state would like you to accept it, and you don't believe her, Aaron Donaldson would be sitting in that seat. And Jamar Tilley not. The only real evidence that we have of him connected to the car, and it's not minimal, is his DNA, and we can infer that he had rented other cars. I'm not denying that. But that again doesn't make him a shooter or guilty of these crimes. The only time you see him at that pawn shop is on the 18th, and he sure wasn't stealthy. Remember, no mask, parked right in front. Miss Fender's activity outside before she comes in at the Lake City pawn shop is highly suspicious, but of course she denied she had a burner telephone. Well, she admitted she had a burner telephone. She just didn't admit it worked. And she did say that Aaron Dawson had a phone too. Now, if you look at the video close, he's the one you see all the time. Dawson, you don't see much of. John, we'll take care of it now. I want you to take a good look at Dawson and Mr. Tilley, because Dawson's going to come in and they're going to walk up, be next to one another, and then I want you to freeze it, Mr. Woody, if you can. I appreciate Mr. Woody. I think that's him outside, but he'll leave her. They're talking, and he'll end up coming around here and join Mr. Tilley. That's Mr. Saperstein. Now, I'll tell you all the times later, but I think you might have heard it. It was a lot longer and then less stressful than, unfortunately, Mr. Jones had to deal with. Okay. Dawson's going to come around, come through that back door wearing a camouflage jacket, and he's going to come up, and then when he gets right next to Mr. Tilley, Mr. Weed's going to freeze it. Well, I'm wrong. He's coming from that side. There he is in the camouflage jacket. There's no doubt that's Dawson. He's going to, he's really looking for stuff. Tilley's engaged with the guy who can, right there. Okay. Remember when I asked Miss Fender, they're about the same complexion. Oh no, he's lighter. Okay? And then the state right after that introduced a picture of him in which he appeared lighter. There's things, like everything. Pictures, identification, lighting, factors. He ain't lighter than him there. He's darker. But wait, what was his name? What was the guy's name that managed the tin metal shed business right next door to that? Well, he got a description too of him, Mr. Dawson. I'll get to that name in a second. I'm trying to remember. It's on here. I'll get to it. And he said that Mr. Dawson was his height. Remember? He and I had a height contest. I probably wasn't quite as tall as him, but I know how tall I am. I'm 5'9". And he's probably about the same. But he also said that Mr. Dawson built just like him. We know that ain't true. Look at that tall, thin person. Fender said he's tall and thin, taller than Mr. Tilley. Dawson, if Dawson's correct, then that can't be the person we know. But thank goodness we have him for you to judge. He's taller than Tilley, he's thin, and he's dark complected. And honestly, with all due respect, I don't know how you say he's got an inch of hair that will stick out from a baseball cap. You can see it that way if you want, but this is no evidence conclusively that that would happen. The video evidence doesn't present that. It's what you argue if you don't see it. I submit his hair could be covered by a baseball cap. Speculation is a funny thing. Okay. Where's my bottle of water? Where'd I put my water? Oh, thanks. I'm
Yes, sir.
Mouth gets dry up here. Maybe it's from hot air, maybe it's just anything, I don't know. All right. Google search for Walmart. Mr. Wade talked about that. If Mr. Tilley went home to Tallahassee that night, why is he going to Walmart to change clothes? I think he probably could have changed clothes in Tallahassee. Miss Fender obviously testified they were buying cover-up clothes from Walmart. Remember, I asked her, no, she said I stole them. So at that time, she hadn't been charged and convicted of it, despite an admission. But we know then, 5 felonies, and her crimes of dishonesty just went from 2 to 3, even if she ain't charged. It'd been nice to have an investigation that might have told us who went in to that Walmart and not. I talked to one of the police officers, I asked him, you ever been to Walmart? Oh yeah. Security cameras? At first he kind of waffled, of course, 24/7. We could have maybe had that, I don't know. Fender was given all the jewelry from the robbery by Eric Donaldson. What authority? What? I don't know. Again, Mr. Tilley's not connected after the fact with any items that were stolen. What happened to the pistol that was taken from Mr. Jones? You really think Fender don't know? We know from all the evidence, especially Mr. Saperstein, he's got no axe to grind in this matter. His own assertion was they were together at Empire. You can see in the video him leaning over the car out back. They're together. I submit to you the stealthy, suspicious driving behavior is something caused by Mr. Donaldson and her, and not Mr. Tilley. Judge for yourself. Why is that important? It defines their roles better, and it gives you an opportunity to judge who is it on the 20th with her. It's Mr. Tilley, as the state would argue, that Donaldson gives her all the jewelry, his girlfriend of 4 years, and sends her into a pawn shop with a gun in her bookcase where she could be killed if there's a gunfight. I submit that's unreasonable. We can speculate. That's what I'm doing right now too. Either way, but I think that the logic of it really is more Donaldson went in that pawn shop with her. She was the person casing the pawn shop, while Jamar is doing exactly what he did there. She pled to robbery. She's hoping from that stellar performance yesterday, she'll get 7 years in prison, 10 years probation. Look at felony murder, or attempted felony murder. Again, she basically admitted her phone was what we call a burner in the business, meaning there's no records. Again, Donaldson's not seen in the store very long, in the Empire store. In its case in chief, did you see this? These images? Did the state produce it? I mean, they put it on, it's in the evidence. In its case in chief, though, this wasn't presented, this identification. Oh, well, this, I mean, there you go, you got a lineup of two. Usually you like to have 6 or more, or 10, I don't know. There you go. Who's the thinnest? It's hard to tell because he wore a jacket at the time. We can all speculate whatever suits our needs. Who put the arm around her? She knew there was a gun in the pack. Who was close to her, observed by Saperstein in Lake City? Donaldson, not Tilly. Again, I think what Mr. Jones remembers clearly, and as he did at the time, Mr. Weed's correct. When the police asked him, they were here before. Go back and look at the video. He's not identifying Mr. Tilly. He's identifying her and a black male very similar to Tilly, as you can see. And actually, because of the angle, it looks like he might be shorter than Tilly, but he's not. We know he's taller. And he's just as thin. And we're going to convict him based on shoes, very common shoes. People can change their shoes. People can have similar shoes. Okay, now, I'm done dealing with them. They're closing. What I want to tell you now is to look at this, not from what us lawyers say. I had to deal with that. But what the law is and what is the evidence. For the law, I submit to you, right? I mean, look at these main things for deciding the issue of who the shooter was. There was an eyewitness identification instruction. In weighing Ms. Fender's testimony, I submit to you, there is instructions, which I'll get and go over with you, that include accomplice and weighing the evidence. Now, these aren't just suggestions. These are part of the jury instructions. These jury instructions just don't come up by whim, okay? They're very important for you to decide because the justice system wants to help you get whatever you decide right, and they're important. The exhibits and testimony I've probably gone over already, so I'm not going to waste a lot of your time. Well, it ain't wasting time. It's just how much do we repeat ourselves, you know? Daddy used to say, if you told somebody something once and they heard you, you got to keep repeating yourself. That's somebody you really don't want to be talking with because they just ain't listening. The pics right there of Donaldson, the video of Donaldson, the color or shade of Donaldson matches that person who is with Miss Fender, Gold Leaf on the 20th. He has no reason to know or to see where the address of Gold Leaf is. When he's there, he comes up and pulls right up there in the car. All right. Remember, we can't forget the testimony of Travis Williams. We know all 3 of them were involved. We do. We know all 3 were involved on the 20th. We believe. You know, we really don't know all 3 of them was involved on the 20th. Because we don't really know who was driving the car on the 20th, do we? We really don't. We don't know who's really behind all of this. The way that Donaldson's been minimized, he's not on the amended information. We don't know what lies below the tip of the iceberg. We can speculate. There comes a time you got to say, no more speculation. We got to have evidence that convinces us beyond exclusion every reason for doubt. It is nobody's fault here in this courtroom. Okay, I'm gonna wrap this up here in a minute. Let me just go through this. Again, when I repeat this stuff, you rely upon your collective memory. Because I will never intentionally try to tell you something what it is if I don't believe the evidence supports it. But I'm not going to let speculation and spin color all of this, because I don't believe our talk ever comes into play as much as the facts, the evidence, and the law. Get this stuff out of the way. I don't know if you had it in your notes, but upon questioning by the state, Fender says, they, but she talked in we a lot too, gave me all the jewelry because Aaron owed me. You know, it might sound ridiculous, but why would Mr. Tilley do that? Why would he go in with a gun to turn around and give all the jewelry to her? How confidently she busted that jewelry case while Mr. Jones lay on the floor. I don't know. The court said, be fair, keep an open mind. It's important. Travis Williams, first witness. He saw the people on the 20th, the two people in the gator outfit. He was able to identify, to some degree, Miss Fender. And that's been corroborated. I don't think there's any doubt Miss Fender was there. We know that by her own admission, by the videos. Even though she didn't look much, you know, like the lady on the video. But time has passed. People lose weight, gain weight, hair color changes, hair falls out. It's a problem with eyewitness identification. Well, don't matter. He calls it a gray automobile. I don't think you can really pick on him for that. I looked at that rental. I was looking hard because they described the car in the rental agreement. It doesn't have a car. I don't think they think it's that important. I would have put a cover, but it certainly isn't white unless it's on that one video. Okay, but he doesn't identify either the driver of the car or whoever was in the gator blue attire. You know, from the video and from his own testimony, Deputy Sheriff Peter Morello was the first on the scene from local law enforcement. And we know that the most significant thing from that testimony was also on the video, that the people that were there 2 days before Mr. Jones said were the people that came in and robbed him and shot him. Again, I submit to you, how would Mr. Jones, if their clothes are changed, when a gun's looking at him right in the face, know the difference wearing a mask? What he knows is the same appearing people were there before. That's what he knows. He saw the firearm. Mr. Jones indicated he saw the firearm real close. Was he influenced by his view or reviewing of the videos in preparation for trial and after? I would submit he probably was. Could he have been mistaken? Absolutely. He says he knew the same based on the eyes. Okay? That can be a reason. Mr. Saperstein didn't say that. He had more time, didn't have a gun in his face. And you know that. Look, right there. More time. All right, Mr. Galler. I'm just reviewing now. Saw two males and a female. The one in the camouflage was short, stocky build, like him. Here's the point of it. I don't think he was lying. That's what he remembered. But that's just about the Mr. Saperstein, who did not make an identification and remember Mr. Tilley, had more of an opportunity. In fact, Mr. Saperstein, at first I thought it was 1 minute and 5 seconds, but I'm sitting there timing it while I'm watching it, that they're in this close proximity. It's 1 minute and 9 seconds. Okay. Probably not a big difference. Direct. No gun. I think that would make you highly question if Mr. Allen Jones was correct. Not intentionally, trying to he's mistaken. I don't think that there's any question that Mr. Tilley is involved in the car. I just don't think you should give it that much weight as to him being the shooter. Involved in the crimes? Very likely. But again, you get rid of Mr. Jones's testimony if you believe it's mistaken, and you don't believe Fender, there's no difference. Actually, there is. Look at this video where Mr. Donaldson is outside talking to her, the conduct of the car, while the whole time Jamar's sitting in there doing the same thing he did on the 18th. Again, they're stupid in a lot of different ways. I don't think none of them are real smart, but the lead investigator, Mr. Kelly, said he arrested Mr. Tilley, who was driving the car in Lake City, which again is unlike Fender and Donaldson's stealthy getaway from the hotel late at night. The DNA, well, what we have is it confirms Tilley's hands were on the steering wheel. We already know that. Kelly told you he was driving the vehicle when he stopped him. And, you know, make a big deal about a cover on the car. Then don't drive the car. Again, then Martin Lee that was the Columbia County deputy. I don't know why I asked him that question. I think he was mumbling a little bit, but I don't know. I just can't hear him real good. I think I've talked enough about Victoria Fender. Draw on your own notes and what you think about that, but I think she's not truthful or worthy of belief. You think somebody like that has any real concern about the oath? Swear and tell the truth? Think she does? That's up for you to decide. She said there was no plan to rob the Empire Pond. Why is she saying that, driving like that? Parked in the headed that way. Well, there's no evidence of Mr. Tilley, but there sure is evidence of her and Donaldson. Oh, they denied their own telephone contact, but he's sure reaching over that car telling her something. Then look at his behavior when he comes in and starts looking like he's interested in something, as opposed to Mr. Tilley, who's trying to get him a witness. If he's stealthy, if he's so smart, why is he trying to, that's what that is. That's a witness. for 1:09. Put the gun in her book bag. Okay, 7 years in probation, what she's hoping to accomplish. I'm going to go over these jury instructions with you real quick and I'll be done. You don't need them right now. I'm just going to highlight ones I think you need to give. Do whatever you want, you know. I'm just advocating a position. I'm not telling you what you have to do. I hope you at least bear in mind what I'm asking. First, you got to follow the law. And a verdict can't be based because you feel sorry or are angry at anyone. It's a cold, just fact-finding decision that should be done on the evidence and the law, not the lawyers, and not emotion. It's almost like, why don't we just use robots then? You know? But I understand it. Nobody can look at that video. No one can look at Mr. Jones and not feel sorry and not want to seek some type of revenge. If it was my family, I guarantee you that's the way I'd feel. But that ain't the way we judge in court. It's got to be set aside. First, second, you can only decide the case on the evidence, not on the argument of how you think the evidence should be. Neither mine nor Mr. Williams. We're not on trial. Okay, eyewitness identification. You've heard the testimony of 2 eyewitness identifications. Mr. Jones and Miss Fender. Yes. In deciding how much weight to give to this testimony, you may consider the various factors mentioned in these instructions concerning credibility of witnesses. Now see, they're not written that say you shall, you may. You can just conclude that none of this matters and agree with whomever you want. But I suggest you should not. You should consider these factors. That's why they're there, and it gives you some guidance. I've been in the legal field 37 years. We have different viewpoints, just from experience. I can't do what y'all can do, and I don't do what I do very good, but I try. In addition to those factors, in evaluating eyewitness identification, you may also consider the capacity and opportunity of the eyewitness to observe the offender based upon the length of time for observation and the conditions at the time of observation, including lighting and distance. Well, plug in what I've said to that. I don't need to keep haranguing it. Whether the identification was the product of the eyewitness's own recollection or was a result of influence or suggestiveness. I do not believe that Mr. Jones was influenced by law enforcement in an intentional way to have him just identify Mr. Tilley. I'm not saying that. What I'm saying is there's ample evidence to suggest his memory is based solely upon those videos and not based upon his statement at the scene. I saw them 2 days before. He saw a black man and a white woman. Again, I know the shirt thing, okay? I know that. It was Jamar and it was Miss Fender 2 days before. It was Jamar the same day with the same shirt on right there. Okay? Remember who came in on the 20th though? Completely different clothes, similar shoes. How much weight you give that? Convict somebody based on common shoes. We don't know whose shoes was wearing who, or if Donaldson didn't have the same kind of shoe. We don't know. But the actions afterwards, the actions at Empire suggest this guy, look at the videos, this guy, he leaves 11 o'clock at night, take it on the loop back. We don't know that. But well, we do know it because they gave the jewelry according to her. So what else was taking the gun? Wonder who got the gun. Okay. The circumstances under which the defendant was presented to the eyewitness for identification. Mr. Saperstein, a gun in your face. But not only that, when you look at the video, look at how much he's actually looking at Mr. Tilley if he's not even talking to him, as he said he wasn't, and how much time he was spending focused on Miss Fender. Any instance in which the eyewitness did not make an identification when given the opportunity to do so. Now, that really don't apply. The witness's familiarity with the subject identified. I don't think he had any familiarity with him. Lapses of time between the event and the identification. 2 days. But how could you really know the difference between these two guys if they're wearing masks and they're dressed differently? Whether the eyewitness and the offender are of different races or ethnic groups, and whether this may have affected the accuracy of the identification. Wow, maybe I knew that before I told you he's remembering a black person and a white person. Look, it's real. We can live in a made-up BS world, but look, different races view other races differently for identification purposes. If not, it wouldn't be in the jury instruction. The totality of the circumstances. That's very important. All right. When talking about witnesses, and this is applying to Ms. Fender, you must consider the testimony of some witnesses. It's bathroom sink water. With more caution than others. For example, a witness who claims to have helped the defendant commit a crime or hopes to gain more favorable treatment in his or her own case may have a reason to make a false statement in order to strike a good bargain with the state. I give our courts a lot of credit for putting this stuff in. And it's not, well, some lawyers are involved, but it's mainly the courts, because they sit in courtrooms day after day and, you know, see these issues as they arise. And this instruction is something that's very serious. So, if the other evidence, it says, though, convinces you that the identification was good, then you can believe the witness. What other evidence do we really have that will make you believe Miss Fender? And there's nothing that we can do if Mr. Jones was mistaken. It would have been a mistake. But do we convict someone of these horrible crimes based on that? Lastly, in weighing the evidence, among other things, was the witness honest and straightforward in answering questions? Did the witness have some interest in how the case should be decided? Has the witness been offered or received any preferred treatment or money or any benefit? I keep saying this. Look at the felony murder instruction you get and figure out a way that it does not apply to Miss Fender, because based on this performance, 7 years probation if the judge accepts it. That was her testimony. Now, I've heard many times, well, we have to make a deal with the little devil to get the big devil. You know, I understand that. There's no question who she is. There's no question of what she did. Ladies and gentlemen, I'm going to take all my papers. I'm not even going to have to write notes because I don't get to talk to y'all no more. And I guarantee, well, I'm pretty sure in a very professional way, very articulate way, the state will tell you everything I've said has been rebutted by the evidence and that I'm full of beans, just like my grandson says. But I'm not. I'm not. Y'all do what you think the just thing is to do. It's a serious matter. Thank you.
All right, thank you, Mr. Collins. Members of the jury, we're going to take a recess. We've been in session just at an hour. I've got 11:14. If I can get all of you back in place at 11:30. 11:30, that'll give you just about 15 minutes for your recess. Remember again, just a reminder, don't discuss the case, don't do any sort of investigation on your own, and don't let anyone discuss it in your presence as well. Any question from any juror? If you would, do as you have been recently. When you do return, if you want to step outside, that's fine, use the restroom, just have a seat in the seat that you're now sitting here in the courtroom. We should be ready right at 11:30. Any further instructions requested from counsel?
No, Your Honor.
All right, we'll be in recess, 15 minutes.
He hasn't been on us to do this. Yesterday, every other time.
All right, state ready to conclude? Yes. All right, may proceed.
First, want to begin with responding to some of the things Mr. Collins said. First and foremost, the testimony from Victoria Fender was that she gave the jewelry to the defendant because the defendant, Aaron Donaldson owed money to the defendant. That was the testimony that Victoria Fender gave. Victoria Fender didn't keep the jewelry. She didn't owe money to Aaron Donaldson. She said Aaron Donaldson owed money to the defendant and that she gave the jewelry to the defendant because Aaron Donaldson owed him money. Simple. So, and again, you got to rely on your own recollection, but that's what I recollect that Victoria Fender said. Now, another thing, probably not even a big deal, but just I want to stress, the defendant searched for a gold leaf. He didn't look for directions to gold leaf on the 19th, but regardless, it doesn't matter. He was searching and looking for gold leaf on the 19th. I know Mr. Collins said he was searching for directions, but he was searching for information about gold leaf. And I know Mr. Collins also said that, made a lot of comments about Aaron Donaldson. Aaron Donaldson, that'll be for another day, another proceeding, not for here. But let me just say this, that the notion that Victoria Fender is somehow covering for Aaron Donaldson, that doesn't really make any sense. Because think about the jury instructions that you got. And I want to point out one specific instruction that you got. That's principles. And let me read it to you. It says, if the defendant helped another person or persons commit or attempt to commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person or person did if the defendant had a conscious intent that the criminal act be done, and the defendant did some act or said some word which was intended to and which did incite, cause, encourage, assist, or advise the other person or persons to actually commit or attempt to commit the crime. And the final line, to be a principal, the defendant does not have to be present when the crime is committed or attempted. Okay, so what does all that mean? Law of principles here in Florida. You've heard of aiding and abetting a person, I'm sure. Well, in Florida, we have principle law, which says that if you help a person commit a crime, then you're just as guilty for that crime. You don't even have to be there, as the last line says. You just help somebody. So, help somebody by giving a bank robbery. Other person goes inside and robs the bank. You never go inside. You're just a getaway driver. Guess what? You're just as guilty. You're just as guilty. You help somebody, you're just as guilty. And that's the reason why Miss Fender was charged with all the crimes that she got charged. So I'm sure she's fully aware what the principle was. She didn't have the firearm. She just took the items. But as a principal, you help, you're just as guilty, right? Why do I bring that up? Okay, the defense is saying that Victoria Fender is somehow helping out Aaron Donaldson by saying that he was just the getaway driver. According to the law, Victoria Fender has fully implicated Aaron Donaldson. So how in the world is she helping him? This is not making any sense. Victoria Fender says that Aaron was driving the car. Therefore, Aaron Donaldson is guilty of everything. Attempted murder, felony attempted murder, robbery. Aaron Donaldson can be convicted of all of those. Just like Ms. Fender can be convicted of all of those. So it begs the question then, and how in the world is Ms. Fender, who's trying to get leniency, going to tell the truth? So she's going to implicate Aaron Donaldson by saying he's the driver, fully implicate him according to the law. He can be found guilty of all the same crimes, but yet she's going to implicate him, but then shelter him. I don't understand. That theory doesn't make sense. Now I want to talk about the charged offenses and the law as they apply to them. And I want to look at the verdict form, okay? I know you got the jury instructions, but let's take a look at the verdict form. And this is the verdict form that you're going to be getting, all right? Now, there's choices for each count. Now, it says right there, as to count one, check only one. Well, you see a selection A, and That is for the defendant is guilty of attempted first-degree premeditated murder as charged in the information. Then underneath section A, you have some questions to answer. But then there's another option. Option B, the defendant is not guilty. So I know this form is a little confusing because it says only check one and you see a bunch of different places to check. You check only A, B, C, or D. So you pick one of those choices. Then you answer the questions underneath each one of those. Okay, so for count one, have the defendant charged with attempted first-degree murder, all right? And of course, there's lesser included charges I'll talk about in a minute, but I'm going to ask that you find him guilty of attempted first-degree murder. Why? What is first-degree murder, first of all, then we'll talk about attempt. The jury instructions you got said that first-degree murder is premeditated murder. It also says that premeditated murder is not some long, drawn-out plan. Defines premeditation as the defendant had, after reflection, a conscious decision to kill. That's premeditation, conscious decision to kill. Now, you may ask yourself, well, how do we know the defendant had a conscious decision to kill whenever he was shooting Mr. Jones? Well, if you ever heard the adage, actions speak louder than words, there you go. Because a lot of times people don't profess what their intent is, like, I am wanting to kill you as they shoot you. You gotta look at their actions, and that's what the jury instructions also say. You look at their actions. You can look at their actions to determine that. So what does the actions tell us about what the defendant did? Shot Mr. Jones at point blank range multiple times. In fact, as Mr. Jones was going on the floor, he was continuing to shoot him. What do those actions tell you? That tells you that he had an intent to kill. Not trying to just hurt him. Unloading those bullets is more than just trying to hurt him, which would be more in line with second-degree murder or manslaughter. But this was first-degree murder because multiple times shooting at him, that shows a conscious decision to kill. By the way, also it should be mentioned the fact that the defendant was already thinking about firing his firearm, because remember, Mr. Fender said that he went to test fire the weapon before. So again, actions speak louder than words. What was he doing before? Test firing the gun, putting the gun in the backpack. He gets the gun out, and you can see in the video, he just makes the decision, gets the gun out and fires and fires and fires and fires and keeps on firing until he's practically empty. That's a conscious decision to kill. So, defendant should be found guilty of attempted first-degree murder. Simple. Then there's some questions to answer under that section about whether he had a firearm or not, or whether there was great bodily harm or not. I think those answers are pretty easy once you determine that he's guilty of attempted first-degree murder. Yes, he did have a firearm. Was there a discharge of the firearm causing great bodily harm to Mr. Jones? Of course. So then you look at count two, okay? And count two is very similar. They have a couple of choices. But choice A under count two, the defendant is guilty of attempted felony murder as charged in the information. Well, what's felony murder? And the jury instructions, you can read all this, and I'm kind of simplifying it to try to help you, but you can read the instructions. But first of all, felony murder, what does that mean? That's when a person commits a felony and ends up killing somebody during it. And it doesn't matter the intent to kill. There's no intent to kill. In other words, if a person is committing a felony, such as this case, robbery, and doesn't even intend to kill the person, just says, well, I think I'll just fire a warning shot, but does end up killing them, that's felony murder. You kill somebody during a murder. Now, in this particular charge, we have attempted felony murder. Defendant was engaged in a felony robbery, and during that robbery, shot Mr. Jones, but Mr. Jones lives, so he's guilty of attempted felony murder. One little thing, too, if you read the jury instructions, and it may sound confusing, but it's really not. The instructions say that for attempted felony murder, that the defendant do some action that could have caused the death. Well, in this case, that action that could have caused the death is shooting Mr. Jones. And that particular action, shooting Mr. Jones, is not a necessary element or a necessary part or necessary to commit robbery. In other words, the shooting of Mr. Jones was something above and beyond what had to take place for the robbery. And yet, what was necessary for the robbery, okay? So robbery doesn't require you to shoot somebody. Now, we'll talk about robbery in a second, but it does require violence and threat of violence, but it doesn't require shooting somebody. So in this case, we do have the defendant guilty of attempted felony murder. He did an act above robbery. He was committing a robbery. In the course of committing the robbery, he shot Mr. Jones, but Mr. Jones lived. So there again, attempted felony murder. Then it should be found guilty of that. I mean, you have the lesser included offense, and you can see on there of attempted manslaughter, and we'll talk about lesser included offenses for count 1 and for count 2. You do have those choices, but the lesser included offense really just doesn't tell the full story in this case. For instance, if you find the defendant guilty of attempted manslaughter for count 2, that instead of attempted felony murder, aren't just overlooking the fact that he was committing a felony in the course of it? Because attempted manslaughter don't require you to be committing a felony at the time. So, find him guilty of attempted manslaughter, just overlooking the fact that, well, I mean, he did more than that. He was committing a felony at the time, therefore it should be attempted felony murder. And remember, the judge instructed you, in the instruction packet will say that you should find the defendant guilty of the highest charge proven. So, the evidence says he was committing a felony. During that felony, he shot, almost killed Mr. Jones. So that's the highest charge offense. Manslaughter, you're leaving a lot out when you pick that offense. Okay, finally we have count 3, or I'm sorry, count 4. And it's numbered differently, but don't worry about it. I know there's no count 3. And then for here we have the defendant is, choice A, the defendant is guilty of armed robbery as charged in the information. Robbery, first of all, let me explain that, because some people, they will use terms like robbery, theft, and burglary interchangeably. But the legal definition of theft as opposed to robbery is theft, stealing something, simply put, okay? Theft, taking something. Robbery, taking something, but with force. Force of violence, threat of violence, or something of that matter. You could take somebody from something without using any force or violence. You know, shoplift something. All right, you stole something, you didn't use force or violence. Go up to the cash register, point a gun in the cash register or the cashier's face and say, give me your money. Now you're using force or violence. That's a robbery. So in this case, we had a taking, a theft of the rings and the gun of Mr. Jones. And in the course of that taking or theft, there was violence used, obviously. So therefore, this is a robbery, not a theft. You do have the lesser included offenses of theft to consider. Okay, problem with that is, this was more than just a theft. If you find the defendant guilty of just one of the theft lesser includeds, overlooking the violence that was used in this, which makes it a robbery, not a theft. So I'd ask that you find the defendant guilty for count 4 of armed robbery. All right? I appreciate all the attention that you've given in this case, and I think that, you know, you all have really paid attention very well. The evidence is pretty clear in this case. I'm not going to rehash what I said before. I would ask that you just consider that. But all the evidence, you connect the dots, you consider the compelling testimony of Alan Jones, you consider the testimony of Victoria Fender and what she's got to gain and what she's got to lose, and you consider all the other evidence. I think there's just an inescapable conclusion here. It was the defendant that committed these crimes. The defendant sitting right here, Jamar Tilley. And it is the defendant who should be found guilty as charged on count 1, attempted murder, on count 2, attempted felony murder, and on count 4, armed robbery or robbery with a firearm. Thank you.
Mr. Weed, members of the jury, I have about 10 minutes till 12. There's no way for me to determine how long it'll take for you all to deliberate. And you may not know that, obviously, at this point in time as well. I'm going to give you the option here of two, one of which is go on to lunch now and then return at 1 o'clock. And I have some very, very brief instructions for you before you go back to deliberate. Option two would be for me to go ahead and give you those last final instructions and have you begin your deliberations now or within a couple minutes. Of course, you'd then have to work through the lunch hour, and depending upon your choice, if you're still deliberating after a period of time and want some lunch, we can make arrangements to do that, which again may take some time to get it to you. Probably the safest thing, if you're asking me, but I'm going to let you decide, is for y'all to come back at 1 o'clock, go get some lunch, and then I'll give you, like I said, the final brief instruction, then you can begin your deliberations. But I'm going to leave the choice up to you. How many of you want to come back at 1 o'clock? Just raise your hand. Okay, majority rules, and we got 4, so no sense to see what the others wanted because I have an idea. But anyway, majority rules, so what we're going to do then is take a recess here, and I'm going to ask all of you to be back promptly, as you have, at 1 p.m., and then, like I said, I'll give you this brief instruction, and then you can go downstairs to begin your deliberations. One final reminder, please, again, do not discuss this case with anyone. Don't let anyone discuss it in your presence, and don't do any sort of blogging, tweeting, texting, looking at the internet at all regarding anything regarding this case or anybody involved. Any questions from any member of the jury? Any further instructions requested from counsel for the state? Defense? Okay. All right, we'll see y'all back at 1 o'clock. Leave your notepads here, please. And court will be in recess till 1 p.m.